Okay, so from unit 4, we have point number 5, limitation of taking cognizance. Okay, now this thing roughly we have seen in another topic as well. So what is cognizance?
To take notice.
Taking notice, correct. So magistrate, once police officer sends a report or someone files a complaint, magistrate to take notice of it, magistrate to start the process. That is nothing but cognizance of offenses. But is that power absolute, that whenever a person approaches the magistrate, whenever police officer sends a report, is it that in every single time magistrate to take cognizance, or are there some limits or restrictions on that? That is what we are going to discuss. Hey, before we continue, I wanted to inform you about my live mentorship program for LL.B students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. In case of civil wrongs, right, we want to, like it's not that severe. So in case of civil wrongs, there are limitations for each and every single thing. And Limitation Act clearly specifies that within this duration, you should be filing a case. Otherwise, your right itself will be gone. Right to claim compensation, right to claim for any kind of relief, that right itself would be gone. But when we talk about criminal wrongs, right, as such, specifying a limit does not make much sense because crime has been committed, right? One person has done something wrong, he should be given punishment and he should learn from that. That is why, as such, in criminal, in criminal cases, as such, we don't say that there is a limitation to file a case. Once a crime is committed, victim is having a right to approach the police station, approach the court. Okay, but putting a limitation makes sense in some minor offenses because with time, evidences get erased, right? It becomes difficult, more and more difficult to prove the crime. Witnesses may forget specific details of what happened on that day. So it makes sense to put limitation in certain cases, but in most of the other cases, there is no limitation. Okay, so when we study this topic, limits to take cognizance of offenses, this is not applicable in each and every criminal case. Okay, it is applicable only in less severe criminal cases wherein punishment is lesser. There only it is applicable. So what is this limitation? It is mentioned in chapter 36 of CrPC, sections 467 to 473. First of all, it provides a definition. Okay, and it says when we are using the word period of limitation, okay, it mainly specifies the limitation period. Okay, what is the limit within which we need to approach? And this is with reference to 468. That means section 468 clarifies in what all cases limitation is applicable, how it would be counted, everything is specified. Okay, so when we are talking about limitation, period of limitation, it is not applicable in every single criminal case, but it is applicable only for the cases which are mentioned or specified in section 468. So 468 specifies bar to take cognizance of offenses. Where is it that some restriction will be applicable? Okay, so it says no court shall take cognizance of offense after expiry of the period specified. So this table specifies a time limit. Offense punishable with, depending on the punishment, we are specifying the limitation. Okay, we would see what is the maximum prescribed punishment for that offense. Based on that, we would say, okay, this is the limitation period for it. And if you look at your punishments are very less. Okay, in case it is a crime which is punishable only with fine, there is no provision for imprisonment as such, it's just fine, 500 rupees, 2000 rupees, whatever. If it is punishable only with fine, within 6 months, we should file the case. After 6 months, period of limitation will be over. There will be a bar to take cognizance of offense. Court will not be able to take cognizance after expiry of 6 months. Okay, so this table you can remember, it is easy also, it is important as well. Okay, that in case only it is punishable with fine, limitation is 6 months. Second classification is imprisonment not exceeding 1 year. That is for offenses which are punishable with imprisonment. Person can be sent to the prison. But for how long can he be sent to prison? Not
1 year.
exceeding 1 year. It may be 3 months, 6 months or something like that, but not exceeding 1 year. In such cases, period of limitation is also 1 year. So you can remember, right? 1 year, 1 year. Punishment is up to 1 year means limitation is also 1 year.
1 year, yeah.
It is minimum 1 year and maximum 3 years. In such a case, limitation is also 3 years. So it's like similar, right? Maximum 3 years, it is 3 years. Lesser than 1 year, it is 1 year. Only fine 6 months. So this is what limitation is, and it is only applicable in cases wherein punishment is lesser than 3 years. More than that, there is no limitation as such. Okay. Now, when we talk about limitation, we need to count as well, right? From what day the time is starting, when it would end, everything we need to count as well. So in computing the period of limitation for offenses, where two offenses are tried together, most of the times it happens, right? A case may be filed under the provisions of rioting also, under the provisions of causing hurt also, under the provisions of criminal trespass also. So if there are more than like 2 or more than 2 offenses, and all of these are tried together, in such cases, how we will see the limitation, because punishments might be different, right? Somewhere punishment is 6 months, somewhere punishment is 2 years, somewhere punishment is 7 years. So in case we are talking about a case wherein 2 offenses are tried together or more than 2 offenses are tried together, the period of limitations shall be determined in pursuance of offense which is punishable with the more severe punishment. Okay, so more severe one we would consider. Based on that, we will fix the limitation as well.
Yes.
So this is applicable only when there are more than one sections or more than one heads of crime under which the case is filed. But now, fine, we know what is the limitation. Okay, but now when is it that the time would be starting? On which date time would start? Is it the date of commission of crime, date when police was informed, date when magistrate was informed, date when the person came to know? When is it? That time frame would start. So that is specified in section 469, which says, in general, okay, in general, period of limitation will start on the day when the offense was committed. When the offense was committed, from there only we will say limitation also starts. The day from which such period of limitation begins shall be excluded. So that particular day is excluded. Okay, it means that first day from which the period of limitation begins to be calculated shall not be included. Like take for example, offense was committed on maybe 1st of May 2019. We would count it from 2nd of May 2019 only. Okay, because at night also case crime might be committed. So it makes no sense counting that day. So from the next day, time would be calculated. Okay, so ideally what happens whenever the crime was committed, from that point in time, you calculate if today crime was committed 31st of March 2022, we will count the day from 1st of
Okay.
April. Okay, the next day we will count. That is the ideal situation. But it is not that easy. There may be some times wherein person aggrieved by the act had no knowledge regarding commission of the offense or the police officer. It begins on the day when it comes to knowledge of the aggrieved party or police making an investigation into the case, whichever is earlier. It might happen that there is a theft taking place in someone's house, right? They went for a vacation and there was a theft taking place at their house. Now, until and unless they return or someone informs them, they would not even come to know about it, right? So in such a case, period of limitation will not start from when the crime was committed, but it will start when they came to know about it. If they are returning from the vacation after 15 days, after 15 days only, time will be calculated. Okay, so ideally from the time offense was committed, if person had no knowledge, then when he came to know about it, there it would start. Okay, third is when the person who has committed an act is unknown or not being identified. The first date on which the accused was known, either to the aggrieved person or to the police officer making an investigation into the case, whichever is earlier. Most of the times we see in case of theft, right? Theft happened. They went for a vacation. During that time, theft happened. Now, they might not be knowing who is the person who committed the crime, right? So they will file an FIR and they will say person unknown. Theft has taken place, that is for sure, but who committed the crime, that person is not identified yet, right? In such a case, again, time would start only when they come to know about who committed the crime. Only when the person is identified, from there time would begin for them. Okay. Because when a case is filed, court would need to issue summons and everything, right? It makes no sense. Whom would court issue summons? Whom would court call to the court? Right? So time would be given that you get details of that particular person. After that also you can file the case. This is nothing but when period of limitation would start, and there the day when crime was committed, we would exclude that particular day. From the next day onwards, it would be counted. If it is 1st of May, from 2nd of May, we would count it. Is it clear?
Yes, madam.
Now, exclusion of date on which the court is closed. It may happen that we are saying that, okay, fine, 6 months limitation you have, 1 year limitation you have, 3 years limitation you have. On the day when was your like last date to file the case, maybe court was closed, right? So exclusion of date on which court was closed. The day when court is closed is excluded from being credited in specified period of limitation. It is a rule that in case when the period of limitation expires on the day of closure of the court proceedings, court proceedings, the cognizance of the offense is taken when court reopens. If court was closed, maybe because it was Sunday, because of some holiday, summer vacation, winter vacation, whatever. If court was closed on that last day, it would be considered that whenever court is opening that particular date, they can file the case as well.
Yes.
Now, fine, there are certain offenses which just happens at once, right? Theft. Theft, only one day it would happen and it's done, right? But there are certain offenses which are continuing offenses, right? Like in case of cheating, in case of fraud, forgery, some things, right? It is a continuing offense that every single time forgery is happening, every single time cheating is happening, every single time illegal transaction is taking place. That is nothing but a continuing offense which may continue for years altogether also, right? In such a case, what happens is a fresh period of limitation shall begin to run at every moment of time during which offense continues. Take for example, it is an offense of theft. Okay, and every single day what is happening is that maybe a person is constructing some terracotta like pots, Okay, one person is constructing some terracotta pots and you will keep it outside for drying and burning it and everything. And his neighbor, every single day, he is stealing 5 of such terracotta pots. It is a continuing offense, right? One person would every single day make some terracotta pots. He would keep it outside. His neighbor would steal it. Every single day it is happening. This is a continuing offense. So if this happened for 6 months, 3 years, 4 years, 5 years, limitation period would begin afresh. Every single time again, it would again be like counted as day one. Is it clear, or I should give another example?
Clear, madam.
Clear, right? Yeah. So every single time it would be counted, and it's like never ending process, right? 3 years, 2 years, whatever, it would never end.
Because if there is 100 crime or 100 stealing, 100 date of limitation will be applicable.
Yeah. 100 days, again, it would be starting.
Yes.
Okay, so today stealing happened. Today it starts. From today we will count. Tomorrow again it is happening. Means today again from day one we will count. After 5 days again happening, from day one again we will count. Like that we would start again with day one, like that.
Yeah.
Okay, next is extension of period in certain cases. The court may take cognizance of an offense after expiry of period of limitation if it is satisfied on the facts and circumstances of the case that delay was properly explained. Parties can even go to the court and they can explain why was there a delay. If they can give like satisfactory reasons, they can ask the court that kindly excuse us, because of this it happened, and court may accept also if it is found to be like a genuine reason. Okay.
Yes.
So that is about the limitation. Okay, what all limitations are applicable and what all situations it is applicable. And this table is very important. You can just remember this table. Fine, 6 months, lesser than 1 year, 1 year, 1 year to 3 years, 3 years. This is very important.